Well, thank you so much, Lee. I appreciate the opportunity to talk to everybody today. It's interesting. I've spoken with some communities. We had a lot of questions regarding this legislative session and some bills that were proposed and some language that was included. And even as I went through kind of an earlier presentation that I had done for some communities that had requested it, a month and a half ago, how fast everything moves, things that are taken out. I wanted to just really highlight, Lee, your involvement with CEOMC and with other advocacy groups, for staying involved with the legislative process and advising your clients and your managers of these changes and how they're going to impact their communities. I mean, you've been very involved. And I want everybody to know that. I think of how important I think that you take this and how from Vesta, from a staying on top of it, advising your communities, and commitment to education. So thank you for what you do and for putting this on. So I think that what I'd like to do is, and one thing just to get started, just a couple housekeeping things. If you can use the Q&A button for anybody that does have questions, that's the best way for me to see what questions are asked, and then I can mark them as answered so I can make sure I get through them. The other thing is just that we are recording this. I believe Vesta will make a copy of the recording available. What I provide though is not legal advice. I'm kind of providing a general update. A lot of things you're going to hear me say, I'm not sure what they were thinking, or this might conflict with this, right? So we're all kind of going through this together. Some things there's further information to come. But I'll be happy to try to answer any general questions and where I can see it impacting your communities. But please understand that this isn't legal advice, and that how it affects your community, I would recommend talking with your legal counsel. If you don't already work with us, just talk with your community association attorney to see how it's going to impact your community. The interesting thing too this year is that we really have changes that affect both condominiums and homeowners associations throughout the state. The last couple of years, there's been changes that maybe predominantly affect one group over the other. This year, we have a blend. There's a couple of bigger bills that passed, and we'll be sure to go through all these. Oh, and good question. I just saw one that just came up here real quick. So all of these bills have passed. They have not yet been presented to the governor for signature. However, we don't have any expectation. None of these are controversial that we're worried about the governor vetoing these. The governor does not have a pocket veto, which means that unless he actually vetoes them, once they're presented, they become effective even if he doesn't act. So I want to make that clear. So everything that we're looking at has been passed, but it has not been signed into law yet where we have the effective dates. So if there are changes to that, I know that we'll help make sure to communicate. I know Vesta will communicate that. But that's a good question too. So, and I have that notated on each of the bills that we're talking about. All right, so let's pull up the PowerPoint here. All right. So these are the main bills we're going to be talking about. There's about 6 of these. The first one is House Bill 1029. It's the My Safe Florida Condominium Pilot Program. After that, we'll talk about House Bill 1203. That's the big HOA bill. Then there's House Bill 1021. I said it's community associations. It's largely affecting condominiums, and then some items related to managers and their license, and then the DBPR. There's a bill we'll briefly touch on regarding vacation rentals. There's another HOA bill, House Bill 59, that deals with rules and covenants. And then the last one, just a very brief overview, is House Bill 1503 there were some changes for Citizens Property Insurance Corporation and really applicability to condominium associations. So these are the main ones that we want to talk about that passed. So before I jump in real quick though, a couple of bills that had a lot of attention or a lot of questions that did not pass that maybe you've heard about. One was, and especially, a lot of associations and management companies were concerned with, was the estoppel bill. Every year, it seems like, or every other year, we're seeing legislation related to estoppel bills. Brief overview: an estoppel is typically requested when in connection with the sale or the refinancing of property. It requires the association to answer certain questions so that the buyer or the lender can understand, certain obligations. If there's any outstanding assessments, especially if there's any outstanding violation, there's certain form requirement that's in the statute. The big fight has been the ability to charge certain fees for that. And I think there's a misconception that it's a very quick, I'm going to open up a program here, and within 3 clicks, I can generate an estoppel. So why should I be able to charge for it? There's a lot that goes into it. Originally, they tried taking away the ability to charge that, which would have led to a lot of extra expenses for associations because that's additional cost and time incurred by the party preparing the estoppel that's usually passed through. Thankfully, through really the entire legislative process and lobbying efforts from a couple organizations, I mentioned CEOMC, CAI, which is Community Associations Institute, really, I think, do a lot to the lobbying efforts against it, that bill did not pass. Now, I say all this, you say, well, why does it matter, Ed? Be on the lookout in future years. I don't think it's something that's going to go away, and it could have an impact on associations. We notified associations that we worked with regarding why we thought, the concerns we had with that. So that's one good thing that I would say that did not pass. The other thing was, and this is probably the one I received the most calls on, it was legislation that was proposed. Actually, I'm up here in Northeast Florida. I believe it was a representative from Jacksonville that basically would have required associations to provide 15% of their revenue to the community. So whatever, like they're outside of their HOA, that you'd have to take 15% of your revenue each year and use it in a way to benefit your community. And that led to a whole host of questions. How could this be? How can that be? How are we gonna, that means we're gonna have a shortfall in our budget. Do we have to then increase it to then budget for that? Thankfully, that did not go anywhere. It really didn't get past any earlier stages on committee, but it was a big topic. I received a lot of calls from HOAs that I represented. That did not go anywhere. I don't know that we're going to see that try to come back anytime in the future. So those are the bigger ones that did not pass. There are other bills that were proposed that didn't receive as much traction, and kind of what tends to happen is if the sponsor of that sees it's not going to make their way through, they'll lend their support to a bill that they see is going to make it in exchange for getting key provisions put in place. That's how a lot of this process works. So again, these are the bills that we're going to be talking about that did pass. I'm going to go through them section by section. If you can ask any questions that you have, and then I'll attempt to answer them while we're in them. If we're getting too many, I might want to hold some of them to the end just to make sure we get through this, but please feel free to ask me any questions and I'll do my best to answer them, understanding that this is all new for us too, and I can give my impression based on what I've seen so far. All right, so House Bill 1029, this is awaiting the governor's signature. If it does go into law, it would be effective on July 1st of 2024. It establishes the My Safe Florida Condominium Pilot Program under Chapter 215.5587 of the Florida statutes. Basically, it's the condominium version of the My State Florida Home Program. And that was created in 2006. Really, though, that started in 2006, but then it didn't receive funding again until 2022. And that's for single family homes and also some townhomes. And really what it is, it's through the Department of Financial Services. It's subject to annual appropriations provided by the state. Okay, so the funding comes from the state on this. And it provides for hurricane mitigation inspections and allows for the application by condominium associations for mitigation grants. So let's talk about like the mitigation inspections. It's an inspection provided to a condo association. If that's going to be done, it must include the following. You have to include an inspection of the property and a report that summarizes the results and identifies recommended improvements. It has to provide a range of cost estimates regarding recommended mitigation improvements, and then information regarding estimated insurance premium discounts. So this is part of that inspection process and what that report would include as part of the inspection. Let's say the inspection then leads to recommended repairs, anything that can be done to assist with wind mitigation or any type of, mitigation, anything that was identified in this inspection report if it is performed, okay? You can apply for a grant to be used by associations to make improvements recommended in that inspection report. It must contain a statement by the president that the association has only submitted a single application for each property that they operate, as well as the name and license number of each contractor that they intend to use for the mitigation project. So you have to show, one, this is our only application. Here's who we're going to use. They're a properly licensed contractor, really to avoid against fraud where we're saying, oh yeah, we're going to do this work. Please give us the money for it, which I'll talk about in a little bit, and then them not doing it, right? So you have to show that you're planning to perform this work. And it must include a notarized statement that the association will complete the mitigation improvement. So that's part of the grant process. Okay, so what can you get in this grant? An association that's awarded must complete the entire mitigation project to receive the final grant award, and you have to make the property available for inspection, probably to make sure that you did the work that you said you're going to do, that you submitted. The construction must be completed and you must submit the result for final inspection within 1 year after receiving the grant approval. The association has to fund $1 for every $2 provided by the state. Okay, so basically the state would fund 2/3. Now there's some limitations right below here, but really there's some matching component, obviously, from the association side. The state's not going to fund the entire. So the grant contribution is not to exceed 50% of the total cost of a roof project. For opening protection related projects, so that's like windows and doors, anything related to that for wind mitigation, there's a maximum grant contribution of $750 per replacement of a window or a door, not to exceed $1,500 per unit, with a maximum grant award of 50% of the cost of the project. You can apply for both. So you can apply for a roof grant and like the window and door grant, but it cannot exceed $175,000 in total for what the association is looking for. So kind of backing up again, association can apply for an inspection that would be performed through the state, where they would send somebody out to do that. They would identify and provide a report. Once that's done, if there are recommended repairs, you can then apply for the grant. Okay, so what are the eligibility requirements for it? You have to be within 15 miles of a coastline. To apply for the inspection, you have to receive approval from either majority vote of the board or majority vote of the total voting interests. I can't imagine why you would have to wait for a member vote. I would imagine the board would want to have that done, right? So it's easier to get the inspection done. To have a grant, though, there's an additional layer from an eligibility. You both have to have either the board vote to proceed with that grant or of the total voting interests. Again, probably the board vote. That's the easier way. You also need unanimous vote of all the owners within the building that's the subject of the mitigation grant. This might be kind of difficult. Obviously, if you have a large building with a bunch of owners, practically it might be difficult to receive to get unanimous consent from those owners to go forward with it. We have to look at this further. If you're a community that's looking at it, and you might not receive all the votes that you need for it, maybe from the standpoint of if it's, for windows and doors, that maybe you exclude those units, for example, if they don't vote in favor, and you can maybe still apply for a grant related to the units where the owners did consent. We need to look at that further. Just talking about what the general eligibility requirements are, though, in the statute. You can take that vote either at a budget meeting or an owner meeting. You must first provide a clear disclosure on a form that's created by the Department of Financial Services. So they'll say, here's the disclosure form that you need to utilize when you're letting your members know that you're looking to proceed with the inspection and then, seeking a grant. The president and the treasurer must sign the disclosure form indicating a copy was provided to each owner, and you have to provide the voting results, whether it's a board vote or the member vote, within 14 days of the vote passing. So kind of it sets forth a procedure for, what you need to actually seek the inspection and then proceed with the grant. And then it talks about funding levels that if you are accepted, how much the state will provide for these mitigation efforts. This has been in place again for HOAs. It started in 2006. My understanding is that then there was no funding for it until starting up again in 2022. So if you're in a townhome within an HOA, I did see some reference to townhomes in the analysis for this legislation, that townhomes can potentially now, I think the question is if the association has the maintenance obligations or insurance obligations related to the townhome buildings, because that can be very document specific, right? So you might need to see eligibility for the association versus an individual owner seeking it. We'd have to take a look at that further. But this is new now for the condominium side. So it's something to be mindful of in a good way to maybe have an inspection done, see what efforts can be done to mitigate, which could then potentially, obviously help you when it comes time for renewal on your insurance premiums, if there's efforts, and then some funding from the state for this. So definitely want to take a look at if you qualify as a condo association to see if it would apply for your community. Is there a risk of getting the assessment and then having that used against us and getting future insurance coverage? So I'm not sure about that. I mean, it's a good question. Like if you're receiving funding, I honestly, I think the funding is really to make necessary repairs or mitigation efforts to make it more likely that you'll get a better renewal on your insurance premium because they've shown that you've undertaken certain efforts. If you don't get the funding. So I think from that standpoint, really, you have to have an inspection done every 3 years anyways as a condo. That's required for like the insurable value of the buildings and everything. To me, I think that if you have an inspection done and there is a recommended list of repairs or efforts that can be taken, I think the association should know about it rather than, well, I wish we never would have done in the first place because now our carrier knows. There's no obligation that you provide that report to your carrier in the statute. Now, whether the carrier might request access to your documents or ask for a copy if you have this, well, that remains to be seen. I don't know that that would prevent me from, I think the upside is much better just from what I can see here than the downside of not getting it and then saying, well, now our carrier knows that we have these recommended repairs that can affect us at renewal time. Oh, okay, so one of the questions was, and I had just addressed this earlier, but it says, can this bill become law if the governor doesn't sign? So what happens is when you present it to the governor, he has a certain period of time to veto it. If he does not, then it becomes effective, even if there's inaction from the governor. So that's the way that this happens. And that happens sometimes. Usually the governor will sign it, but even if it's presented, and I believe it's after 7 or 15 days, that once that expires, if there's no veto by the governor, then it goes into law. All right. All right. So that's what we have on House Bill 1029. Interesting one. I think one for condos, close to the coastline to see they might want to look into that and see if that might be something they can take advantage of. All right. So House Bill 1203, this is for homeowners associations. Again, all these are awaiting the governor's signature. Actually, a lot of these haven't even been presented to the governor yet. Interesting. I'm not sure why, what the timing is on all this. But has passed and pretty much, and this bill passed pretty unanimously, as well as the condo bill that's coming up. So that's why I say that we're not really worried about any type of, governor vetoing this or anything like that. This would be effective on July 1st of this year. There's some changes regarding community association managers. There's a statute for everybody that might not be aware that managers are governed by, there's certain, they have licensure requirements, there's a certain statute that governs the actions for community association managers and management firms. So CAMs that are providing services to an HOA shall attend at least one member or board meeting annually. Non-issue occurs already, right? Must provide members the name and contact information of each manager or representative of the management company, that manager or the representative hours of availability, and a summary of their duties. So that's a proactive requirement now, having to make that available. And the information must be posted on the association's website or mobile application. You have to update the HOA and their members within 14 business days after any change. So if there's a change in the, in the CAM assigned to the community, that needs to be proactively provided within 14 business days. And you have to provide a copy of the CAM or the management contract to any member upon request. That's already been law. I mean, that's already a record that's open for inspection. So that's a change now, I think, from a disclosure standpoint of the people assigned to the communities from the management side, what their general hours of availability are and the scope of their duties. That's the main thing. There's some changes from the CAM statute regarding the number of continuing education hours, and it's more like an organizational change within the DBPR there's like a council there determining the number of continuing education hours, the criteria, and the course content. This is one thing, kind of a reminder. CAMs have a license. They have to have 10 hours each year, and I think it's reporting is every 2 years. So basically 20 hours of continuing education every 2 years. That managers have to go through, and there's different topics, legal updates, operations, financial issues. So that's an ongoing requirement. It does say that the council cannot require more than 10 hours of continuing education annually, which is really what's in place now to make sure it doesn't go up from that. A change, though, is that a CAM that provides services to an HOA must basically every other year complete at least 5 hours of continuing education credit that specifically pertains to HOAs, and then 3 of those hours must relate to record keeping. So we're going to receive some further guidance from the division as to continuing education requirements for managers. You can see here on the HOA side, it has to be HOA specific, and they're focusing a lot more on record keeping. So again, it's governing more your managers, and for our managers on the call here, regarding your continuing education requirements. So talking about official records for HOAs, it clarifies that you have to maintain them for at least 7 years unless the documents of the community require longer. This is a big change that for HOAs that don't already have a website, if you have 100 or more parcels in your community, by January 1st of next year, you have to have a website and post certain documents to it. It's in the statute that talks about what those documents are. We can provide more detail on that upon request. It's similar to what's been in place for the condo statute. But I've kind of, if you've attended a class I've had before where this has been in a law now, I think since January of 2019, condo associations of 150 units or more have had that website. And I said, it's only a matter of time before it's for HOAs. Now we have it. So it's 100 parcels or more. You have to have a website, or you can have a mobile application in lieu of the website that if the mobile app is able to be downloaded onto your mobile device. You also have to ensure that the records not accessible to parcel owners are not posted on the website or the mobile app, which has already been in place. We've already recommended that. This is an affirmative requirement now. HOAs have to adopt written rules governing the method or policy by which official records are to be retained and the time period that the records are going to be retained. I would say that this could be in conjunction with any rules regarding the inspection of records, that you've already been able to adopt as an association. But this is an obligation now for all HOAs to have written rules governing the method or policy by which official records are to be retained. This is new. We're looking at this of how really, if we're going to receive further guidance on it, whether really all you need to do is adopt a rule that says we're a community of 100 parcels or more, therefore we have a website. Everybody will receive a login and all of our records will be there. Anything that isn't required to be on the website will be at our management company's office, which is within the county. Something along those lines, kind of further confirming how your records are going to be maintained. I think that would be what this is requiring. So you're going to really need to work with management and really get your legal counsel involved just to make sure that the rules adopted are compliant with what the new statutory, provision is going to be, assuming it's not vetoed or anything, right? You have an obligation to make the official records available. It's dependent upon a written request from the parcel owner. So there's been some back and forth in recent years on the parcel owner versus their authorized representative. This seems to be limiting it back now that the actual owner has to make the official record inspection request. And then just to, again, confirm, and they set this out in the statute, you have 3 ways to make your records available: having them available for inspection or copying in the community, making them available electronically via the internet, like through a website or a mobile app, or on a computer screen at the association or the management office and then printed upon request. You have to, there's some compliance with law enforcement requirement. You have to provide a copy of records or otherwise make them available to law enforcement agency within 5 business days after receipt of a subpoena. There's also a requirement that you comply and assist with any law enforcement if there's any effort, if they're investigating a crime. Then they've established, and this is kind of a theme we've seen, and you'll see this also in the condo bill, is that there are criminal penalties associated with certain activities. One is repeated violation of the statute governing records retention and making records available, knowingly and intentionally defacing or destroying accounting records with the intent of causing harm, or the refusal to provide access to records with intent to avoid or to escape detection, arrest, trial, or punishment for the commission of a crime, or assisting somebody else. And there's some criminal penalties, unfortunately, associated with this. So the word repeated is defined as twice within a 12-month period. So you can see they're trying to impose criminal penalties on managers and directors, depending on who has the oversight on this, for not complying with it, repeatedly violating the record retention and making records available provision of the statute. Let's see. So financial reports. So an HOA with at least 1,000 parcels. So if you're familiar with it, you have a financial reporting requirement each year, but it's dependent on the total amount of annual revenues that you receive, and that determines the threshold of what type of financial report you have to provide. What this provides is that if you have 1,000 parcels or more, you have to have an audited report regardless of your annual revenue. The threshold for having an audit has always been $500,000 or more of annual revenue. In this case, let's say you're a 1,000 parcel association, but you only have annual revenues of 250,000. You would now have to have an audit done and not the lower. I think that would be a compiled statement if I remembered, or a reviewed statement. So increased financial reporting requirements for large associations. There is a mechanism in the statute to waive or reduce your financial reporting requirement. You have to have majority approval of the members at a meeting where a quorum is met. This says that you cannot waive to reduce or either waive or reduce your financial reporting requirement in consecutive years. So if you have to have an audit done every year, you can only vote every other year to do away with the audit requirement. There's a crackdown on debit cards for both HOAs and for condos. It says that you cannot use a debit card in the name of the association or bill directly. I need to clarify this. It says if you use a debit card for unauthorized expenses, then it's deemed to be a theft. All right. So where that could happen is if a board member used a debit card and what they allege to be an association expense, but it really wasn't, that's considered to be theft. And there's provisions under 812.014 for what the ramifications and penalties are for that. So again, big thing, don't use debit cards. It's the best way to do it because obviously once that money's out, you don't have the way to track it through like a normal credit card and putting a hold on anything and tracking it. So that's for both HOAs and for condos. It's been in place for condos, but they further clarified the theft element if there's a rebuttable presumption there, depending on what you use it for. So from an accounting side, a parcel owner or any occupant, licensee, or invitee of the parcel owner can make a written request for a detailed accounting of any amounts owed. But really what this is related to is to fines. You have to provide that information within 15 business days after receipt. Otherwise, your ability to collect fines is waived. Once requested, you cannot request again for 90 days. So if you fail to provide it, you're not allowed to collect any fines that are more than 30 days past due. So that's the main takeaway is if somebody's asking for an accounting related to their fines, you need to provide that within 15 business days. So there's some changes in the architectural review process. You cannot limit or place requirements on the interior of a structure that's not visible from the parcel's frontage, an adjacent parcel, an adjacent common area, or it says a community golf course, and that's newer. The question is what is a community golf course one that's private but is within your community, right? Like it's adjacent to your HOA. That's open for interpretation right now. I represent some communities that we receive complaints from people that are board members that play golf and then they're on the golf cart path on the private golf course, but they can see violations in the backyard within the HOA. There's a question there of whether or not that's a community golf course or if you need to see it from an actual parcel that's part of the HOA or not. So there's some room for interpretation there. You cannot require review and approval of plans or specifications for a central AC, refrigeration, heating, or ventilating system if it's not visible from the parcel's frontage and is substantially similar to a system that's approved or recommended by the association. If you have any denial from an architectural review for anything, this is a broad point. The reason for the denial must be providing in writing, and you have to reference the specific rule or covenant. So if you receive an architectural application, you're denying it. It's not enough just to say it's denied. You have to say it's denied because of the following provision. And maybe it might just say, hey, it's not any specific thing. We just don't think it fits within the aesthetics of the community. And this provision allows us discretion on that. That may be what you have to reference, but it's more of a pinpointing to them so they can see exactly why you're denying any type of architectural application. 720-3045 was put into place last year. I've received a lot of questions on that, and I think there's a misconception regarding it. Really, what that statute has said, and they've kind of expanded as to other things that you're not allowed to enforce against if it's not visible. It just says that if you can't, even if something is a violation per your covenants or your rules, if it's not visible from the parcel's frontage or an adjacent parcel, then they added again here the adjacent common area or a community golf course. If it's not visible, you can't enforce against it. That's kind of what the rule is. There's some interpretation there, like I said, of what's an adjacent parcel. If you're in the second floor of a home and you can see down on your neighbor's parcel, are you on the adjacent parcel? I tend to think yes. I don't think it has to be just from the ground level. There's what is an adjacent parcel, and then I mentioned the community golf course issue. But if you can still see something and it fits within that, you can still enforce against it. So I want to make that clear. It's not. I've received some questions of, are we no longer allowed to enforce against sheds or artificial turf that's in somebody's backyard? I said, yes, you can if you can still see it, and if it's set forth. So they just expanded additional things that you cannot enforce against if they're not visible. All right, so there's changes to the fining and suspension process. This is a big one, and I was really discussing this with other attorneys in our office and I'll tell you where I really see this impacting some communities, okay? So the first part is that the committee, so you have the fining process where the board imposes the fine, then you provide them 14 days notice at least for a hearing in front of the committee that cannot be made up of directors, officers, or employees, or their family members, kind of the impartial fining committee. That hearing has to be held within 90 days that the hearing notice was first provided. They can hold that hearing by telephone or electronic means, so Zoom, FaceTime, Teams, whatever. You do have to provide written notice of the decision within 7 days of the date of the hearing. But this is the big one. A violation that's been cured either before the hearing or after the notice is provided that the fine was imposed and that this is the corrective action, because that's a requirement now that you have to tell them exactly what they need to do to fix it, both in the hearing notice and in the post-hearing written notice saying, yes, you're fined, you're still in violation, this is what you need to do to correct it. It says that if it's corrected after that date, that the fine cannot be collected, which is really a problem, I think, for communities where people are going to abuse it, I think, and wait, maybe even leading up to the committee hearing, or maybe even waiting afterwards, because now, and we have this on the next slide, is that the fine isn't due for 30 days until after the date that the notice is provided, that even if it was upheld. This is just for HOAs only, right? Where I see a problem with this is that parking violations, trash bins, I call it moving violations, any type of violation that can be repeated but technically corrected, very quickly. So like if you leave your garbage bins out for too long, right? And let's say you pull them in, but you're 12 hours too late. Well, you've corrected the violation, but if you do it next week, it's a repeated issue, right? The problem is that by finally bringing it in, arguably they've cured the violation. Same thing with if you're parking on the grass, you go to work, it's no longer parked on the grass, therefore you've cured it. And then when you come back, it's a new violation each time. But if they cure it before the time of the hearing, might not be able to fine for it. And I think that's a big problem. I've talked to lobbyists that we've worked with regarding it. There's some argument, well, no, there's a provision in the statute that might still allow for it. I don't think it was written that way. And a lot of our attorneys in our office say the same thing. I've talked to other attorneys. So big picture takeaway, if you're in an HOA that has been fining for parking or trash bin or other violations that can be corrected but repeated frequently, might be hard to actually fine for those. And I really make sure you talk with legal counsel and your management company to make sure that we don't run afoul of something where they can challenge the fine there. Now, that doesn't mean that they get to get away with these parking violations. I always get this question too of, well, if we can't fine for it, does that just mean that they're allowed to violate our covenants? No, it just means that you might not have the ability to fine based on the way that the statute reads right now. What it means is you might need to get legal counsel involved earlier by sending a demand letter, ordering the activity to stop. And then really, you do have an ability as an HOA to get in front of a judge on this. It does require you to go through pre-suit mediation before you can just go ahead and file a lawsuit. But you could send a pre-suit mediation demand saying, hey, you are constantly in violation of our parking restrictions. We're offering to mediate this to reach an agreement on it. That then if that agreement is reached and if it's breached, you can file a lawsuit for breach of that mediation agreement, right? But if you don't reach an agreement at that mediation, you can go file a lawsuit for an injunction from the court. That's basically asking the court to tell them you are in violation, you need to stop this. And if they don't, then you can ask for sanctions from the judge. So there are ways to enforce it. The problem is like the fining process, if it's done right, can help avoid getting your attorney involved because the fines are a deterrent. If you're not able to fine for some of these violations, you might have to get your attorney involved much sooner. And that's a shame because, and I've been saying, you might say, well, Ed, you're an attorney. Does that mean more work for you? Yes, but we have other issues to not have to deal with parking violations that could have been handled through the fining process, right? So that's a big takeaway. I would say one of the biggest ones, if you're in an HOA that has parking restrictions and constant violations, be mindful of this for when it goes into effect on July 1st, assuming it's not vetoed by the governor. So again, let's assume though, putting those aside, that you do have a violation, the fine's been imposed, and then you send the written notice within 7 days. It now says that the fine is not able to be collected until 30 days after the date of that notice. Okay, so additional time to come into compliance before you can start then collecting that fine. You have the ability to seek attorney's fees if you bring subsequent litigations. Like I mentioned before on the enforcement side, if you have to get an attorney involved and go through pre-suit mediation, if you have to litigate that, you are able to seek attorney's fees. Otherwise, it would be cost prohibitive, right? You don't want to pay an attorney more just to get an injunction and not get those fees back. So you do have that right in your documents and in the statute. This is further clarifying how far back you can get those attorney's fees. It says that attorney's fees and costs may not be awarded against the parcel owner based on actions taken by the board before the date set for the fine. Okay, so really it's like you have to get through the fining process and then tell them when the fine would start. And then any attorney's fees after that would then be able to be collected in connection with the fining process. If the violation is not cured or the fine is not paid per written notice sent after the hearing, then reasonable attorney's fees and costs may be awarded to the association. They had different language here that was thankfully taken out, where a party could appeal how much the attorney was charging and request a meeting with the board and all that. That was removed. Continued fining and suspensions. I know there's a lot here. Notwithstanding any, so we talked about, like, this basically says that you cannot levy a fine or oppose a suspension for a couple things. One, for trash. If they bring it out within 24 hours of the dedicated time for the pickup, or if they leave it out and bring it in within 24 hours, then notwithstanding any rule that you have, that would not be subject to a violation. That's what the state statute says. It's going to say if the law goes into effect. The other one is for holiday decorations, that even if holiday decorations are light or on a structure for longer than what your documents allow, you cannot, it's not subject to a fine unless it stays up for at least a week after you send them notice of the violation. So there's, again, another grace period, or what the reasonable time period is you have to provide them before the violation and the fine can go into effect. One thing I'll say with all of this, as with any legislative change, anything that attempts to change what your covenants may already provide carries with it the potential for the association saying, hey, this law is unconstitutional because you cannot retroactively affect covenants that we already have in place. And we do not have language in our covenants. And most HOAs do not have what I would call auto updating language, where it would say, hey, your HOA is subject to chapter 720 as amended from time to time. That would be language you need to see where it says, hey, we're going to implement any changes to the statute. If you don't have that, and most don't, then it's difficult for the legislature to impose substantive restrictions that impair contractual rights you already have. So I bring this up to say that there are options for associations to say, you know what, we don't think this applies to us because we think this is unconstitutional and we're willing to fight over it. Now, that's a choice for the board to make if they want to do that and really want to talk with legal counsel of if that's worth the fight. But I bring that up just to not say this absolutely 100% is applicable to existing associations. I think there's a valid argument for it. It's just you have to take that cost benefit analysis and working with your legal counsel when this law goes into effect, as we assume it will, to see if you're going to have it apply to your community or not. So I want to bring that up. And that's been the discussion point on that 720-30-45 regarding the visibility issue. That's a similar one. We've had that discussion with communities we've represented. All right, on fraudulent voting activities. Actually, let me just take a quick look to see if there's any question on the fining before I jump in, because I know we covered a lot there. All right, so that question on the ARB and the notification, this is only an HOA bill, so this is only affecting HOAs. Carol asks, are there any rules for HOAs regarding solar panels on roof of homes? Yeah, there is a statute already in place. It's outside of 720. I think it's 163 is the chapter. I have to double check that. But there's a statute regarding renewable energy devices, and it specifically talks about solar panels, and that you cannot have your covenants or guidelines in a way that effectively prohibits the installation of solar panels. This is always kind of a hot topic of, maybe where the house is facing and what you can require. I think my opinion has always been that I think you have to find a way to allow solar panels in some way, but you are able to dictate in some way the location of them. Like, common thing that comes up is solar panels are on the front facing the road, and if you have restrictions against it, you can say, we're not allowing you to put them there. We will allow you to put them on other parts of the house. And that can lead to some issues there. I don't want to spend too much more time, but just know that there are laws in effect. And I would talk with legal counsel. If you're looking at denying any type of a solar panel application, I'd be cautious of doing that before talking with legal counsel, because there are statutes that protect that right to do it under certain limitations. And yeah, Thomas, just again, 1203, this is an HOA only statute. There's a big condo bill that's coming up too. So I know we have a mix of everybody here. So thanks everybody for bearing with if it's not for your community. Sometimes though, it's interesting that, we'll find that the HOA borrows from what's already been the Condo Act and then vice versa. So some of this stuff may cross over at some point too, regardless of the type of community that you're in. All right, so they talk about fraudulent voting activities. This has been in place already. They further clarify it, that certain acts constitute a first-degree misdemeanor. Basically aiding and abetting or advising a person in the commission of a fraudulent voting activity related to elections, agreeing, conspiring, combining, or confederating, I like that word, with at least one other person to commit a fraudulent voting activity, or having knowledge of a fraudulent voting activity and giving aid to the offender, basically. So this constitutes a first-degree misdemeanor, and that kind of supplements what's already been in place. That came into law, I think it was last year, actually. So we're talking about prohibited clauses. There's a statute that says that you're not allowed to have this provision in your governing documents, for example, or you're prohibited from doing anything that violates the following. And that statute already has language regarding flags and entitlement to flags for HOAs. What this says is that HOA documents may not preclude, and really this is related, a lot of it, to parking. You're not allowed to preclude an owner, tenant, guest, or invitee from parking their own personal vehicle, including a pickup truck, in the property owner's driveway. You cannot prohibit, regardless of any official insignia or visible designation, a property owner or their tenant, guest, or invitee for parking their work vehicle. So if you have commercial vehicle restrictions, you may not be able to apply those, again, subject into the argument of whether or not this law is constitutional for existing covenants and rules, right? So I always have to give that disclaimer. But basically, this would be allowing people that have work vehicles, even if they're commercial, to allow them to stay in their driveway. There is a statute that governs what a commercial motor vehicle is, but it's not what you would expect. When we think of commercial vehicles in the HOA context, it's largely from advertising a business, decals, that sort of thing. The statute that's referenced here, 320.01, really is related to like the weight and the size of the vehicle. It doesn't really matter as much like the insignia or any designations. You can have an unmarked vehicle that could still be commercial under the statute. So that statute's largely not going to control, because I know have a lot of communities. I live in one right now, one of my neighbors, so I'm friends with, but he has a business and he's parking his truck in his driveway. There's been an argument of whether or not that's a violation of the, I don't mind it, but we have rules in place, right? This would, when this goes into effect, would allow it, again, subject to that constitutional argument. And then there's another one, that part 4 talks again about the commercial vehicles. But part 3 that I talk about here is you're not allowed to have a property owner from inviting, hiring, or allowing entry to a contractor or worker on the parcel solely because they're not on a preferred vendor list. So be careful if you're trying to prevent somebody that's not on a preferred vendor list. That's where this is basically trying to preclude. You cannot preclude a property owner from inviting, hiring, or allowing entry to a contractor or worker on their parcel solely because they don't have a professional license either. So if you're trying to say only licensed workers are allowed in our community, even if they're doing work just for an owner, this would prohibit that, again, subject to any constitutional arguments. All right. This clarifies, these are some kind of like miscellaneous provisions. So we've talked about kind of, broad topics there, multiple changes. These are kind of one-off for different sections for HOAs. One just clarifies that you cannot charge compound interest on assessments. Your assessment accrues just on the assessment balance each month, not on previously accrued interest, that sort of thing. Electronic voting, members can consent electronically to electronic voting. This is like a little thing in the statute that we've kind of already said was okay. The statute says, as a refresher, that you can implement electronic voting by board resolution. A member, though, has to opt into electronic voting. It used to say you have to provide written consent, but many of these companies provide like a digital way for you to consent to opt into it. This clarifies that, yes, you can provide electronic consent. So that helps, tie that up. An association may not prohibit a first responder, that's a parcel owner, a tenant, or a guest, from parking their first responder vehicle in an area that they have a right to park. So basically, you might have certain restrictions against certain type of vehicles, basically saying don't mess with first responders, for lack of a better term. There's continued change here on the last point about kickback. So this has been a topic that we've seen for the last couple of years in the legislature, that a director, officer, or manager cannot solicit, offer to accept, or accept a kickback. A kickback is basically receiving some type of item of value or service without any consideration being provided by somebody that is either providing a service or is offering to provide a service for the community. What's new is that a violation of that can constitute a third-degree felony to the party accepting it. What's interesting is it doesn't have any applicability to the party offering the kickback. It's just to the party that would be receiving it, which would be a director, officer, or a manager really related to the association, or a family member. You can't skirt this by saying, I'm going to give it to a family member and then it get back to them, right? It does say it constitutes a third-degree felony and also subject to monetary damages. So really cracking down on kickbacks. There's a board education requirement for HOAs. This is a new one. We kind of saw this and it stayed in the bill throughout. As of until July of this year, you could do one of two things when you become a new board member. You can either sign a certificate saying that I've read my documents, I'm going to agree to abide by them to the best of my abilities, or I can take a state approved course. This says you have to do both. I think most people get a lot of value out of that. I know that we usually teach a board certification course through Vesta. And I think that taking that already is valuable. Now it's going to be mandatory. The other thing too is that up until like this change now would say that even if you've been consistently on your board for a decade, it now says that every 4 years you have to renew that by basically taking the course again, which probably not a bad thing, probably good to have a refresher. I have so many board members though that attend a class every year anyways. This now makes a requirement that you have to complete the course every 4 years. And then it further clarifies what needs to be included in that course. I know that the class that I teach already covers these topics, but it talks about financial literacy and transparency, record keeping, levying of fines, and then noticing and meeting requirements, which is largely already included in the class that I and many other people, teach. In addition to that, though, as a new board member, the director of an HOA with fewer than 2,500 parcels has to complete at least 4 hours of continuing education annually. If you have 2,500 parcels or more, it's 8 or more hours. And that's where we're waiting for guidance from the division as to what that is. Like, for example, I'm a continuing education provider for managers to get their continuing education. They might say, if you already have approval for credit for managers, that would also work for board members, for example, right? We don't know yet, but we're going to get some guidance on it. But the main takeaway is that you're going to have continuing education requirements as HOA directors, depending on the size of your community. If you don't timely complete it, you're suspended from the board until you complete it, kind of what's already in place for not completing the new board member certification. And you have to keep those inspections as an official record for at least 5 years after their election and when they take it. All right, so that's what we have on that big HOA bill. And I know, apologize, I know there was a lot there. This next one kind of has a lot also from the condo side. So if you're a condo, you've been waiting, I have some specific stuff for your type of community too. There's a question here. We live in a CDD and they control parking. Does this apply to them? No. So this is only regarding for HOAs specifically. CDDs have their own process and really hoops that they have to jump through. This doesn't affect the CDD's ability from a parking standpoint, though they tend to already be more limited in what they can do versus an HOA. But no, the change that we talked about does not have any application for CDDs. And if you think of any questions that we just talked about too on the HOA side, please feel free to bring them up. I might save them till the end so we can keep going through these. But yeah, thanks for all the questions so far. All right, so House Bill 1021, it says community associations. Really, it's largely for condos. There's some provisions for cooperatives as well. If this goes into law, it would be effective on July 1st. We have no reason to suspect that it won't. So this is the first part is for managers and management companies. There's a requirement that you have to return all records within 20 business days after termination of the management agreement. It does say that if you're terminating a management agreement, it must be sent via certified mail, return receipt requested, or unless if there's a different manner that's allowable under the contract. So if the contract's silent, then it says that you have to provide that by certified mail, return receipt requested. There is a penalty if you don't timely return the records. There's a rebuttable presumption that the CAM or the management company willfully failed to comply. There can be a suspension of the license and then a civil penalty of up to $1,000 per day, up to 10 business days, so up to a $10,000 fine that can be imposed. So putting some teeth on timely providing all of the official records to the association. There's a conflict of interest, the theme, kickback, conflict of interest. So they talk about this in this bill. A CAM or a management company must disclose to the board any activity that may reasonably be construed as a conflict of interest. Now, in my opinion, that's really broad, right? So it's hard to provide, advice on that in terms of what might be and what might not. But it does say that a rebuttable presumption of a conflict of interest exists if a CAM or the management company enters into a contract for goods or services with the association. Now, this is separate from your management contract, right? So if the management company might offer, like amenity services or maintenance services, or if they have an interest in another company that would provide services separate from the management contract, that would be where a conflict of interest, you have to properly disclose it. Or if the manager or the management company holds an interest in or receives compensation from a business entity that conducts or proposes to conduct business with the association. So if it's like a subsidiary or something, if there's a financial relationship there with your current management company, that needs to be disclosed. That's the big takeaway. There's another requirement. So like as part of that, let's say the manager of the management company offers to provide a service separate from their management agreement that exceeds $2,500. There's a statute already on competitive bidding, but it's based upon a percentage of the budget, and $2,500 usually is not going to meet that threshold. But if it's from the management side, that does require multiple bids. And so even if it normally wouldn't because the dollar amount's too low, when it comes from your manager or management company, you do have to solicit multiple bids. That's just good practice anyways, but now it's codifying it and putting it in the statute. This is similar to what's already in place for when board members might have a conflict of interest and they're proposing to enter into a contract like through a company that they're a part of. Any activity that might be a conflict of interest must be listed on the meeting agenda for the next board meeting with the disclosures entered into the written minutes of the meeting, and the copy of the contract must be included with the minutes. And 2/3 of the board must approve the contract, not just a majority like you normally would have to pass anything. So again, some disclosure requirements, what needs to be included in the minutes, and then a higher threshold for the board to approve. At the next membership meeting, the existence of the conflict and the contract must be disclosed to the members. The difference here, though, is that when it's a board member that had an interest, that the members are allowed to vote to cancel that contract. That's not the case on the management side. It's just there's a disclosure requirement. If there's a contract with the management company that's providing services and that it reveals an undisclosed conflict, that contract is voidable and it terminates upon the association filing a written notice. You have to have at least consent of 20% of the voting interest, but once that's done, that's how you can get out of a contract if the conflict isn't properly disclosed. So again, ramifications, voiding a contract, that kind of thing. And also there's disciplinary proceedings for failure to disclose it. So again, conflict, disclosure, that kind of thing. There's a change on the milestone inspection requirement. It really just a small one, might not affect too many in here. They've done this a couple of times now where they're further clarifying who's exempted from it. It now exempts a 4-family dwelling. So you have a 4-unit condo, even if it's 3 stories or less, that previously you would have had a milestone inspection done because it's kind of a smaller building with only 4 units. You don't have to comply with the milestone inspection requirement. It further defines what condominium property is in the statute, what hurricane protection is, and then what constitutes a kickback. We've talked about some of that already. It adds a requirement for the provision in a declaration for residential and mixed-use condominiums, which includes a statement of whether the owner or the association is responsible for the installation, maintenance, repair, or replacement of hurricane protection. That is for preservation and protection of the condominium property and association property. So the question though is like, do you have to proactively amend your documents, or is this for new condos going forward? Really, I would say that it's the latter, right? What if you can't get the votes to amend this, right? So I think this is really for new filing for new condominiums going forward. Again, talking about kickbacks, we talked about this on the management side. If an officer, director, or manager knowingly solicits, offers to accept, or accepts a kickback, it's a 3rd-degree felony, and there's monetary fines that can be imposed. There's also the ability for the division of condominium, once they receive a complaint, they can monitor associations for compliance with the requirement to maintain fidelity bonding or insurance for all persons who control or disperse funds. So there's an additional basically enforcement tool or mechanism that the division has for anything related to fidelity bonding requirements and insurance requirements, which has already been in place, further investigative, and then enforcement powers that's given to the division. Just like in the HOA side, there's a continued prohibition on the use of debit cards, and it provides that any person that uses a debit card in the name of or billed directly to the association for any expense that's not lawful, they commit theft. So that was also provided in the HOA side. So official records on the condo side, email addresses and phone numbers are only accessible if consent to receive notice by electronic transmission is provided, or if the owner has expressly indicated that personal information can be shared. So by default, keep the email address and phone numbers out unless somebody proactively consents whether to receive notice electronically via email, or if they include from a telephone number side to actually include it and allow it to be inspected. An association must ensure that emails and fax numbers are only used for the business operation of the association. There's an obligation to redact that information on any if you have to provide documents to third parties. So if you have an official record that might be open, but it happens to contain email addresses and fax numbers that that person hasn't consented to make that public through, receipt of notice electronically, you need to redact that. So that's going to have some obligation here on redacting for official records that might have that personal contact information. I don't know why this is running on so long here. Sorry for the slide here. Official records now include all invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds by the association, copy of all building permits, and a copy of all board education certificates. Official records must be maintained in an organized manner, and you have to make reasonable efforts to obtain and recover lost, destroyed, or otherwise unavailable records. So there's an obligation there that not enough to say, oh yeah, we don't have it. You have an obligation to proactively look for it, maybe recreate it if you can. So there's an obligation now for condos on that. This is another one that associations are going to have to get this in place, is that whenever you receive an official record inspection, you have to provide a checklist of all the records that are being made available for inspection and copying. So if you receive an official record inspection, what we've always said is you don't have to go through and pick out what they've asked for, right? All you have to do is put the boxes on the table and say, here are all of our official records. Please feel free to review. Now it's not really enough to do it. You would have to provide a checklist to say, if you're going to really make all the records available, you'd have to provide a checklist that says, here are all the documents that we are making available to you. Now, what you could say is kind of cut and paste what the statute says, that these are all the official records you have to make available. So there's going to be some a proactive requirement now to create these checklists whenever you have an official record inspection. The checklist must also identify any of the association's official records that were not made available to the requester. So if you choose to only make the records that they requested available, you have to say, hey, per your request, we're providing these 5 things. These are all the things we're not providing because you didn't request them. And that would be part of that checklist. You have to maintain that checklist that was provided to that owner for a period of 7 years. A lot of things you can see here regarding official records. So there's some penalties now. If a CAM or a director knowingly and repeatedly violates the checklist requirements, there's a 2nd-degree felony. I can't believe that, but it must be removed from office if you're a board member and a vacancy declared repeatedly means 2 or more times in a 12-month period. There's a 1st-degree misdemeanor charge for knowingly defacing or destroying accounting records. The big thing is intent. If you have intent to cause harm, there's a 3rd-degree felony for any person who willfully and knowingly refuses to release or otherwise produce records to avoid basically the detection of a crime or help somebody else with it. So again, similar for what's on the HOA side. Continuing on the official record side, you also have to maintain a copy of all building permits issued for ongoing or planned construction, and that has to be on the association's website or mobile app for associations that are required to have a website. The financial report must be delivered by mail, personal delivery, email, or fax to those that have consented to receive notice electronically, and must provide a notice that a copy of the most recent financial report will be mailed without charge within 5 business days after receipt of a written request. So more proactive financial reporting requirement. You cannot waive or reduce the financial reporting requirement for consecutive years. That's the same thing that was passed in the HOA. So if you have to have an audit done, you can waive it for next year, but then the year after you have to have the audit that was required. So this is a change. So I mentioned before that since 2019, condos of 150 units or more have had to have a website. That's now been reduced down to any 25 unit or more condo has to have a website, but this is now for 2026. So if there's a little bit longer, you've got about at least a year and a half now to prepare for that versus the HOA one, which is, starting January of next year. But for any 25 unit or more condo, you now have to have a website, and it lists the certain documents that you have to make available on it. One thing I always recommend, make sure that your website just has a landing page, that really anything beyond that where you're posting your records needs to be through login. That's to make sure that only your members that are authorized can access it. The reason why I recommend that too is there's kind of a cottage industry that tends to pop up here and then of people testing websites for compliance with any federal laws on ADA or FHA standards. And it's basically a shakedown for money where they're saying they're public testers. So the less ability they have to get into your website, if there's only one front-facing page and that's disability compliant, then you don't have to worry about that. Now it's really limiting it now to the rest of your website only for your association members. So that's kind of a side point, but I always mention that whenever, if you don't have a website already, of making sure it's accessible and only like a front landing page, and then everything behind that needs to be through login. All right, so there's some changes to bylaw requirements. There's mandatory provisions in the bylaws, and if they do not contain such provisions, they're deemed to provide. Now, this is one of those iffy ones of whether or not this is applicable to existing associations that might already have language on this. But this is one of those where these are the provisions unless your documents provide otherwise. So it's not like it's overriding necessarily if you already have something in place on this issue. So a residential condo of 10 or more units has to have at least a quarterly board of directors meeting. Members have the right to attend meetings, and we've always talked about they have the right to attend and comment on agenda items. This has been expanded though now for condos, that in addition to agenda items, they have the right to ask questions on pending construction projects, the status of revenues and expenditures during the fiscal year, and other issues affecting the condo, which I use that in quotes because that's really broad. And so that kind of would open it up, almost like negates the whole, comment on an agenda item. So the statute doesn't say though that you have to answer those questions or what action you have to take from it, just that they are able to comment and ask questions on them. So now though, it's going to be harder for condo associations to say, hey, you're not allowed to bring that up because it's not on the agenda. You have to expand that now based on the statutory change. If the agenda for the board of directors meeting includes approval of a contract for goods or services, this is a big one too. A copy of that contract has to be provided with the notice of that meeting and made available for inspection or posted on the website. So that's not always been the case. It's good practice, and maybe some associations might have a contract available once you get to the meeting. It's never been a requirement. This is one now that you have to provide a copy of that along with the notice of the meeting. So the way I could see it playing out is, let's say you have a 48-hour notice that you post your notice in your agenda in a conspicuous place. That's a normal board of directors meeting, right? If you're going to be approving a contract, what you might say is a copy of this contract, if you have a website, for example, I think the question here is, do you have to also post that along on the board there? Or can you say, hey, it's been posted on our website and that is enough? I think there's going to be some questions associated with this. Because it says a copy must be provided with the notice and be made available for inspection or post on the website. So I would think if you don't have the website, that you're not posting it there, you would need to actually make sure it gets to the members or post it along with the notice itself. So that's a change though. Kind of advance notice and a review by the members of contracts that the board is looking to enter into. So just like on the HOA side, there's board certification and education requirements. There's mandatory attendance at a DBPR approved course for new board members. I talked about that. It's the same as for HOAs. A board certification course. This is a difference, so it has to be at least 4 hours. And the class I teach, it goes 2.5 to 3 hours, and that can be a long time. This is now requiring a more substantial board certification course, and it talks that you have to talk about milestone inspection, structural integrity reserve studies. And then just like kind of with the HOA side, you have to talk about elections, record keeping, financial literacy and transparency, levying of fines, and then notice and meeting requirements. So additional requirements for the board certification and the number of hours, that course has to be. A board member that was elected or appointed before July 1st of this year must comply with that written certification and educational certificate requirement by June 30th of next year. So like, if you're a board member that just signed that certificate but never took the course, and you're on the board after this law goes into effect, you have to basically take that course by June 30th of next year. Really, there's some question there of like 90 days of the law come into effect. I think it just says, since you're already in compliance, I think you just have to take the course by June 30th of next year if you don't do it before that. The certificate is an official record, and it's valid for 7 years. That's different from the HOA, which said only every 4 years, right? So again, some differences between the condo and HOAs of how frequently you have to take this board certification course. A difference though, for a condo side, you have to have a legal update education for at least 1 hour in each year where there's actual substantive changes to laws affecting condominiums. We're going to receive more guidance from the division on that, what that includes, on a lot of the stuff on the continuing education requirements. And then just like on the HOA side, the failure to timely submit the written certificate and educational certificate, you're temporarily suspended until you come into compliance, then you're deemed to be back on the board. A couple things regarding the funding and use of reserves for condos. If a local building official determines that the entire condominium building is uninhabitable due to a natural emergency, then the board, upon approval of a majority of the members, can pause contribution to its reserves until such time that the building is deemed to be habitable. But I think the idea there is if it's uninhabitable and maybe you have an insurance claim, and because sometimes you might choose to not rebuild, and there may be a way that you don't bring your condo back, right? That you don't have to keep funding reserves while it's uninhabitable because you're trying to figure out what to do there. I think that's the intent behind it. Any reserve account funds held by the association may be expended pursuant to the board's determination to make the condominium building and its structures habitable. Upon the determination by the local building official that the building is habitable, you must immediately resume contributing fund to your reserve. So there's some flexibility there of using reserve funds to making the building habitable. On the structural integrity reserve study side, again, this applies to 3-story and higher condominiums. So there's a difference there. Remember, I mentioned earlier that a 4-unit dwelling, if it's 3 stories or less, does not have to comply with the milestone. They still have to comply with the structural integrity reserve study. So there's some difference there if you have one of those. You have to either provide a copy of the structural integrity reserve study to unit owners or a notice that the completed study is available for inspection and copying upon written request within 45 days. So there's a proactive requirement. Once you receive that reserve study report, you have to either proactively provide it to them or tell them a copy is available, and that needs to be done within 45 days. You also have to notify the division that the structural integrity reserve study was completed and that the association provided or made the report available upon request. So there's a proactive reporting requirement to the division now too. So for director and officer offenses, we've talked a lot about like criminal penalties. If a director or officer is charged by information or indictment of certain crimes, they must be removed from office. This is actually now catching up to what was already in place in the HOA statute. It's one of the rare instances where the HOA statute was first. The board can fill the vacancy until the suspension or the term ends. But while those criminal charges are pending, and it talks about certain charges that come into play, whether it's obstruction of justice or preventing access to records in furtherance of a crime or any embezzlement. I think those are the main charges. That's where if you're charged with an indictment or information that's serious enough for them to pursue criminal charges, you're off the board until those charges are dropped. You also can't be appointed back by the board. You can't say, oh yeah, you're off, but we're going to appoint you back a week later. You're not allowed to do that until the charges are dropped. You're also not authorized to access the official records unless there's a court order. So they want to keep those people away from your documents, basically. Fraudulent voting activity. So similar, there's recent legislation that passed a couple of years ago for HOAs. Actually, it was just last year. It provides a first-degree misdemeanor for there's a list of like different activities related to fraudulent voting, whether it's actually changing a vote or attempting to change a vote or bribing somebody or intimidating somebody or providing like a bribe or a kickback. It does clarify, though, that anything of $25 or less, like if you have a pizza party or something that the association has for a meet the candidate night, that's okay. Or if you provide like a pin, or something like, hey, I'm voting for Joe for the board, that's still allowed. But otherwise, like anything to intimidate or affect the election process can be subject to a first-degree misdemeanor. So there's some changes on the hurricane protection side. And this has always been, there's kind of been some back and forth over the last decade at least on what associations can do, what can they require owners when it talks about it. Hurricane protection. Associations are required to adopt hurricane protection specifications for each building. So that's a proactive requirement now. And now specifications may include the color, style, and other factors deemed relevant by the board. Any installation, maintenance, repair, replacement, and operation of a hurricane protection is basically exempt from the material alteration provisions. If you're familiar with that, it says that you cannot undertake a material alteration unless otherwise provided in the governing documents. If the documents are silent, then you need 75% member approval. This is exempted from that, though, if you have proper hurricane protection and you put that in place, even if it is a material alteration. Boards may require unit owners to install a hurricane protection that complies with or exceeds applicable building codes, but you must also have a majority of the voting interest approval if the installation, maintenance, repair, and replacement is not the responsibility of the association. So if it's the board member obligation, then I'm sorry, if it's an owner obligation, then you can actually force that as a board to make them come in compliance with that. All right. If hurricane protection that complies with or exceeds the current applicable building code has been previously installed, then the association cannot require owners to install the same type, right? So if an owner does this and then now the association is doing on a project wide, they can't force that owner to do anything unless the current protection that the owner has reached the end of their useful life, or unless it's necessary to prevent damage to the common elements. So you want to have proof before you make an owner, basically not making an owner pay twice or do something if they've already have protection in place. And a board may not refuse the installation or replacement of hurricane protection by a unit owner which conforms with the specifications adopted by the board, but you can still require the owner to adhere to existing unified building schemes. An owner is not responsible for the cost of any removal or reinstallation of a hurricane protection, including windows, doors, and other apertures, if its removal is necessary for maintenance, repair, or replacement of other condominium or association property for which the association is responsible. If such removal or installation is completed by the association, the cost may not be charged to the unit owner. If the work is completed by the unit owner, then the association must reimburse them for the cost of removal or reinstallation, or the association can apply a credit toward future assessments. But note here, there's a conflict. It says the statute also provides that the removal or reinstallation of the protection is the responsibility of the unit owner and the association completes it, then the cost is the owner's. So we need to, if you're looking at this, I would just get a legal opinion on it, because there is some not uncommon that there's some conflicting language, which then leads to, you know, a glitch bill, basically correcting any drafting errors that was in place. Largely, though, just take a look. If you're either putting in hurricane protection and trying to charge owners that might already have it, or if you're doing something to an owner's installed, you can't charge that back to the owners under certain circumstances. Just make sure you talk with your manager and legal counsel on that. And just providing further, if an owner that's already installed hurricane protection complies with the applicable building code, they're excused from any assessment levied by the association or receives a credit if the association does it for the rest of the project. They still remain responsible, though, for their pro rata share of any hurricane protection installed on the common elements and association property. So ones that don't like go over a window, but might be more like a clubhouse, or, you know, that's only association, you know, maintained and owned property behind that. That would be where the owner would still have that expense. You're just kind of exempting them for the work that they've already done if the association doesn't have to do work related to their unit. One thing too, that this was kind of added at the end, but it's an important topic, is that Chapter 718-124, it was amended to provide that the statute of limitations, this has already been in place, for any cause of action that you can bring, that's tolled. And what tolling means is that the statute doesn't begin to run until a certain date, right? It's stalled. Is that it's until turnover. So once turnover happens, that's when the statute of limitations runs. Usually we look at that for the purposes of, you know, any issue against the developer or any contractor, and that 4-year time period of a known issue doesn't start to run until turnover. The good thing, and we were kind of involved, our firm was, because we represent a lot of communities, especially, you know, dealing with construction defects, is that kind of pushing for an effort to amend this to also say not only the statute of limitations, that's a known issue, but what about latent hidden defects or hidden issues? The statute of repose is kind of like a drop dead date of, hey, regardless of when you become aware, you're still time barred if you don't bring a claim by this date. That's important because last year during the legislative session, if you took a legal update that we provided with Vest on this, know that they reduced down the time period from 10 years to 7 years for that statute of repose for any building defect. And it runs from the earlier of certain trigger dates. So the concern was developers waiting too long to turn over and running out the clock basically to bring a claim because the time period is shrunk. This is extremely useful for condos because now that 7-year period doesn't run until turnover. So that's a huge, you know, relief. I still bring this up to say that law that went into effect last year, reducing it from 10 to 7 years, there's a grace period until July 1st of this year so that you can still bring a timely claim under the old version of the statute. largely applies a lot, to condos or HOAs that were developed over a long period of time. They're going to lose the ability to bring certain claims as of July 1st if you're within a certain time period based on the age of your building. Really recommend that you look into it. The good thing, though, is that this tolling provision was added for turnover. My understanding is that this is really going to be pushed next year for HOAs, and I'm thinking especially for condo or for townhomes, excuse me, that would provide, where the association has maintenance obligation, that tolling that time period until turnover is going to really help so that it prevents the developer from delaying turnover to run out the clock, right? So again, just be mindful of that too. Then the last part really that we'll talk about under this bill is there's the anti-SLAPP statute, which is basically like what you're preventing is you can't retaliate against somebody for exercising their rights to raise complaints or to voice their opinion on an issue. It amended 718-1244 to provide that a condo or any other person may not file any lawsuit or claim against a unit owner without merit, and solely because that owner has exercised the right to instruct their own representatives or the right to petition for redress of grievances before the association or the various governmental agencies. So you can't retaliate for somebody complaining or bringing up an issue that they feel in good faith is a valid issue, right? So it's unlawful to fine or increase an owner's assessments or decrease services or threaten to bring in action or threaten to bring in action based on certain conduct by the owner. And this is examples of some of that conduct, like if an owner has complained in good faith to a governmental agency, or if they've organized, encouraged, or participated in a unit owners organization, or if they filed a complaint alleging criminal violations or violations of the Condo Act, or if they've complained to the association regarding violations of the Condo Act. There's other examples there, but basically somebody voicing their objections to activities, you cannot try to silence them by threatening lawsuits. Right now, that does not prevent if somebody is making, and I get this question a lot from board members is, can I go after somebody for defamation if they're saying things about me that are untrue? This does not take away that private cause of action for a board member if somebody is saying that you are, doing something that you're not doing, right? That's where defamation comes into play. An example would be, hey, our president, John Smith, took $100,000 from our community last year, and that's theft, right? That's a statement of fact. And if that is untrue, John Smith, as the president or whoever the director, can bring an action against that owner. So that is not prohibited by this. What this does prohibit is saying, hey, I think that our board is operating outside and they're not holding meetings that they're required to, that the association cannot retaliate to try to silence them from alleging violations. Now, they might be wrong, right? But we have to be careful about what type of actions and letters that you can send regarding, speech raised by somebody. Just on electronic voting, I talked about the electronic consent on the HOA side. Same thing for condos. You can opt in electronically to vote electronically going forward. If you authorize electronic voting as a board, the board must honor the owner's request to vote at all subsequent elections unless the owner opts out. There's some developer obligations. There's some technical changes regarding escrow or alternative requirements, including the use of deposits for a developer in the sale of the condominiums. One thing, though, that I like to point out is that the developer has to conduct a structural integrity reserve study, and they have to do that within 90 days after turnover of the condo. So they have to, there's an affirmative obligation for the developer to make sure that that is conducted. And then the last slide that we have here on this one, and I'll make sure to get to our questions that we have. So for suspension of voting rights, at least 90 days. So this law has changed a couple of times over the years. It used to be that you had to be 90 days delinquent. Then for condos, it was changed that you have to be 90 days delinquent, and it has to be at least $1,000. And that even if that's the case, that if you vote to suspend, the suspension is not effective for 30 days after. So it kind of gives them a 30-day grace period to become current before the voting rights are turned off. This says that 90 days before the election, you have to notify an owner that their voting rights may be suspended per that process I just mentioned due to non-payment. So there's an extra notice requirement. So this would prevent an association from, like, let's say 31 days prior to the election, having a board meeting and saying, hey, so-and-so is 90 days delinquent and it's $1,000. We're going to give them until the date of the election to come current. If they don't, we're going to toss their ballot. If that's the first time that the owner was notified, then that would then be contrary to what this new law is going to be, which is you have to give them at least 90 days. It's preventing against kind of suspending right before the election, even if it's given that 30-day grace period. So that's one thing associations need to look at further in advance than what they normally have done, I think, on suspension of voting rights. And then the last thing really is just for the division of condominiums, which have a lot of oversight for condominiums, timeshares, and mobile homes. Their authority was generally expanded. I didn't go through all the details here. They just have expanded investigatory and disciplinary authority. The division has to provide certain documents and templates to comply with education requirements. So there's obligations on the division side too. Just know that there's further oversight for complaints and what they can investigate. For really, it's not really something the association gets involved in proactively. It's more, if an owner files a complaint to the division for the actions of the association, what can the division get involved in now? So just like to bring that up. All right, got a couple more bills left, but I want to talk about these, and those are the two big ones. So the next ones aren't going to take us as long, but I want to make sure that I address any questions that we have. Maureen says, our association has single family and townhomes. Does House Bill 1021 apply? So that's the bill we were just talking about. That's only applying to condos. So if you have a mixed use, though, community that has some condos and some townhomes, it would just be for the condominium portion of the community that law would apply to. If there's no compound interest on assessments, can an HOA charge flat fees for late? So this doesn't charge that's a good point. You can charge interest up to 18% per annum, and that's allowed by statute, whether your documents provide for it or not. But on late fees, there's still a cap on what you can charge, which is the greater of $25 or 5% of the missed installment. And you can only charge that late fee in the same frequency as the missed assessment. So if you have $1,000 annual assessment, right, what you would do is you'd want to charge the $50 late fee because that's greater than $25, but that's a one-time a year late fee because you have a one-time assessment. You can charge the interest on that $1,000 on the missed assessments, but for the late fees, you still are capped per the statute. Let's see. All right, Thomas says we have the initial milestone inspection. How often does it need to be done after that? I don't have the materials up in front of me, and when you have your initial milestone inspection done, I believe that it's valid for, I think it's 10 or 15 years, and I might be confusing that with the SERS requirement, but I believe it's 10 or 15 years. It's just that there's the initial upfront now based on the age, and we have so many condos in Florida that are older than 30 years that there's that requirement by the end of the year, this year, that it get done. But I believe it's at least 10 or 15 years after that before the next one would have to be conducted. Can you give the owner view-only access to an AP system? So if you're talking about, like, if that's your way of providing access to official records, yes, you don't have to, you certainly do not provide anything that would allow them to alter any records or any system that you have in place, correct? Can copies of records be electronic? Yes, you definitely, and some communities are going to a completely electronic form of keeping their official records. That's the easiest way to comply and not have to really worry as much about the official record inspection and the time that you make them available. As long as you're timely updating your website and uploading those documents, that's a way to be fully compliant with the official record inspection and maintaining your records. Do HOAs also have to post a copy of the proposed contract? No, it's a good question. That's only in the condo bill. So you can see sometimes there's changes done on one side versus the other. That's not a requirement that's been put in place yet for HOAs. Yeah, a couple questions regarding that. And I will say, though, that even if you don't have to provide that copy in advance, like the condos do with the notice of it or post on the website, the contract is still open for inspection by members. I think it's good practice to at least maybe have a copy of it available at the board meeting so that members can look at it and maybe try to, comment on it as they're looking at it, but there still is no proactive requirement like there is now going to be for HOAs. What size condo unit requires the additional training? So that's the other thing too, is that there's no differentiation for condos for your continuing education requirement. That's for any size. It's on the HOA side that it's the number of hours depending on the size of your community, if you're more or less than 2,500 parcels. There's no distinction there for condos, which means that even if you're in a small condo, you would have to have that board certification course, and which is at least 4 hours, and have to do that every 7 years, and then also the legal update requirements. Do major contracts, for example, roofing, require a vote of the board, or can they be approved solely by executive board? It's going to depend upon what your governing documents provide. You would have to see what the purpose and how that executive board was created. I would say, though, in any instance, that would not be something that could be held in closed session, though. Really, the only time you can have a closed session, so any action that can be taken by the association, whether it's the board, I'd be surprised if that was like a committee that had the ability, and that would depend on if you're a condo or an HOA. By default, though, it should be done in the open in front of the members, though. Yes, we'll make the copy of the slides available for download. I've already provided it to Vestas. I know they can make these available. Confirming the deadline for the structural integrity reserve study. Yeah, so the default is, and this is regardless of the age of the condo, for any 3-story and higher condo, that has to be done by the end of this year. The only exception to that is if your building turns 30 years and has to have the milestone inspection done by, I think, 2026. So that's a small window, right? So if a condo was created in, 1995 or 1996, and so its milestone inspection requirements not until next year or the year after, you can wait to have the SIRS done with that. But for the most part, 90+% of the condos in the state that are 3 stories and higher have to have the reserve study done by the end of this year. There's a question on reserve accounts. Must there be a document that defines what the reserve account applies to? Titles for a reserve account may be vague. Yeah, that's a good point. If you're in a condo, there are mandatory reserves, and we've been talking about the structural reserves that you have to have, and those are set forth by the statute for 3-story and higher condos. But also, even if you're in a 2-story condo, you still have mandatory reserves, and that's for roof replacement, painting, pavement and resurfacing, and any other item that has a deferred expense or replacement cost of $10,000 or more. You do want to be, clear as to what that reserve was set up for. That usually can, if it's a new one, that would be reflected in your minutes, or even if it's been there from the developer, properly identifying how it was set up, at least the best you can determine. The purpose of that is making sure that you're only using the reserves for their intended purpose, right? Can a condominium board require impact glass windows be installed instead of storm shutters, meaning shutters are not allowed and only impact windows are? Yeah, that would require an analysis and a little bit further of what specifications you have. Hurricane protection can be different things, my understanding is. So whether that's impact glass windows versus shutters, I think there's a couple different ways you can have hurricane protection, for example. So I just want to make sure that you look at the statute and what your documents may provide for whose responsibility it is, and then coming up with your specifications, and then whether or not you can mandate it for certain owners if it's their responsibility otherwise. Somebody had asked if we could take a break. I'm almost done, I promise, with a couple of slides. We'll be getting through this pretty quickly, if that's okay with everyone. Is the tolling period for defects retroactive? That's a great point. The problem is that law is not effective yet. And so if it's becoming effective on July 1st and now new statutes are already in place with the reduced time period, I don't see that allowing you to try to use it to go back on the previous turnover language. It's a good question, though, and I would recommend at least talking to your attorney about that, because you don't want to miss out on that time period. I'm not sure if it would apply, though. One question was just explaining turnover. What that is that's the obligation of the developer to allow at least the majority of the board positions to be voted on by the non-developer members. So it's really, turnover is when the homeowners get to take control of at least the majority of the board, and there's certain thresholds for when that has to take place. The most common one is within 3 months of 90% of the units being completed, and that's really for condos or for HOAs. That's really that's the trigger date that then the developer has to schedule that meeting to allow the members to vote for at least a majority of the board members. If someone is running for the board, can they be removed due to non-payments from the ballot? Yeah, so that goes to the eligibility requirements, that your eligibility on the condo side is determined on the date that you submit your intent to be a candidate. If you have a delinquency, that makes you ineligible and you're no longer able to be included on the ballot. If you become delinquent after that, then even if you're elected, you would deem to be automatically removed. It's important to talk with your manager and legal counsel about that. But yes, there are eligibility. The thing, though, is that if you're eligible at the time, there's nothing in the statute that allows you to be removed from the ballot. So what happens then is you would then have out, and you might have a vote for somebody that would then have to be automatically be removed once they're elected. That's the tricky part with it. Does the structural integrity reserve study requirement affect commercial condo associations? So there have been some clarifications there for non-residential versus the residential condominium side. I believe that they did exempt the non-residential condos and that it only applies to residential condominiums. And again, it's 3 stories and higher, right? So just double check that. But I know that last year they had some clarifying aspects to it, and I believe it clarified it was only to residential or the residential portion of a mixed use condominium. Oh yeah, so Stacy, you had asked about when the SERS has to be done. I think I've answered that. The only time it could be by 2026 is if that's when the milestone has to be done for that condo that's 30 years, turning 30 years of age within the next couple of years. That's a small, kind of probably a very small slice of the actual number of condos in the state. So if you're not falling within that requirement, then you have to complete it by the end of this year. Does the requirement for posting contracts with the meeting notices pertain to recurring items or one-time contracts? So what I would say is that if you are entering into any type of contract for services, whether it's a one-time or if it's an ongoing service, the voting on that contract, that contract needs to be provided along with the notice for it. So, but if it provides for, hey, this is a 2-year landscaping agreement, you adopt it once at a board meeting, right? You don't have to provide a copy of it for every subsequent meeting that they're providing service. It's just the initial adoption of that contract. Stacy, you'd said that at insurance webinar yesterday, it was stated that the SERS budget funding goes into effect on January 1st of 2026. No, there's no change in the funding. It's really like, it's the year after you get the SERS report. There was some question of like, if you had this proactively done right away, is it your next year's budget or is it starting in 2025 that you have to fund it? I've given the advice, if you have it in time for your budget meeting, that you should start then including that for your next year's budget. And really, I think it only helps the community to start funding it earlier rather than waiting too long. So my advice has always been, and I'm not aware of any change, and I didn't see any change on this, that if you have it adopted in time for your budget, and especially now we have the cap at the end of this year, you need to start funding it in 2025 going forward, unless you're in one of those small sets that I mentioned where you don't have to have a reserve study done for another couple of years because you're tagging along with the milestone. What are the consequences for condos that are not fully funded by the deadline for their SERS? So if you have little or no reserve funds, yeah. So that's been in place, and they actually indicated that there are certain penalties and there's breach of fiduciary duty claims. And there are, if the manager was involved with that and not recommending or not assisting with that, that there are some licensure complaints that can be made. So there is some teeth to that, and it's subject to, a lawsuit that can be filed by a member challenging the board for non-compliance, and that they can get a court order and get their legal fees paid back. So there's definitely teeth in the statute for non-compliance, both as to the directors and officers as well as the management company. Lisa, you had mentioned the components for the SERS will need to be listed on the balance sheet. No longer can they be pooled with a subledger. So this is one question that's come up of, can you have pooled structural reserves as part of the SERS? We don't have further clarification on it. I was talking with one of the lobbyists again that I mentioned before that was deeply involved with this. The unofficial position, I believe, is that you can have pooled reserve for the structural components. The big thing is you're not mixing the structural components with the non-structural, because there's different, you can still vote to waive or reduce the non-structural reserves. I think it would be permissible to have a pooled structural component reserve. We don't have full clarification on that. But from what I've been told, it looks like, and I think even that's from an informal position from the division, that would be acceptable. The big thing is it's only for structural components. So you're not taking out of a structural reserve to do the repaving, for example, right? All right. All right, great questions. So you can have 2 line items. Yes, you would have your structural components and your non-structural components, correct. All right. Real quick on vacation rentals. Probably the big thing here, more of just like what's not included and just to be mindful of it going forward. But I'll talk just kind of what the changes are in case this impacts some of your communities. It does provide for payment of taxes by an operator listing a vacation rental with an advertising platform. It does grandfather any county or local law that was in place prior to January of 2016 and any amendments that were adopted prior to January of 2024 regarding vacation rentals. But you're not allowed to basically adopt any amendments after January of this year to the existing policy. unless it's to make it less restrictive, basically. There's a lot, basically what you're seeing is there's a lifting of finding authority and enforcement power regarding vacation rental operators. This one is for the failure to provide the division with their unique local registration number. That used to be something that you could find them as part of the registration process. It exempts the maximum overnight occupancy requirements from, there's like a 15-day cure period before you can be fined for violations. It limits liens for unpaid fines related to vacation rental violations from the operator. It deletes the requirement for advertising platforms to verify the vacation rental license number with the unique identifier in the local registration, so less verifying requirements from the advertising platform. It deletes the requirement that the advertising platform notify the division within 15 days after any advertising or listing fails to display it. So again, kind of lifting some of the requirements there and reporting requirements that doesn't have that license number or local registration number. And it limits information that advertising platforms must report to the division each quarter. And that's limited down to the internet address of the advertisement and the vacation rental license number, and if applicable, the local registration number. So I bring all this up because there's always kind of constant changes to the vacation rental statute. One of the things that I know that CAI was part of was fighting against. There was an initial attempt, and I think we're going to keep seeing it, of trying to exempt your covenants or trying to prevent you from enforcing your covenants against any vacation rentals. So the vacation rental lobby is a big lobby. They don't like having covenants in place that restricts the ability to utilize vacation rentals. That was successfully removed from this bill. Again, would have been subject to a constitutional argument anyways. I bring this up to say, if you have a community with vacation rentals, or if you have restrictions preventing against it, it's always important to kind of stay mindful of what's going on in the legislature. There's always attempts that we see, whether it's every year, every other year, to try to prevent associations from having restrictions preventing against it, which obviously is a huge hurdle to get over from a constitutional standpoint. Doesn't mean, though, that the effort's not there. So something to just be mindful. It's why I wanted to bring it up. Just a couple of brief changes. This is on the HOA side again, regarding your rules and covenants. It adds a subsection to 72303, which is kind of the large general association governance portion of the statute. It says that before October 1st of 2024, the association shall provide a physical or digital copy of the association's rules and covenants to every member of the association and to every new member. So what that could be, that seems to apply to every obviously existing community. Now, if you have a website and you make it available on the website, I would see that there can be compliance of, hey, this is to notify you, and you do this by October 1st of 2024, that here's where all of our covenants and our rules and regulations can be found. I think that would comply with it. And then you have to provide a copy of them to every new member. If there's any amendment, the association must provide every member an updated copy of the amended rules and covenants. So this is interesting. It's like changing. You've had to, in the HOA side, you've had to already provide a copy of an amendment once it's been recorded within a certain time period. This seems to imply whether or not you have to provide the full list of updated documents. It does say that the association can adopt rules establishing standards for the manner of distribution and the time frame for providing those copies. Again, if you're going to be having a website, or if you already have a website, I would think that adopting a rule stating that whenever we amend our documents, it's going to be on our website where we maintain everything else, and maybe we'll provide you with notification of it, but that's where you can go. I think that should be compliant, but again, talk with your legal counsel on that to make sure there's no issues with it. The requirements, like I said, may be met by posting a complete copy of the rules and covenants or a direct link on the homepage of the website if the website is accessible to members of the association. And you do have to notify them saying, hey, going forward, this is where we are going to be uploading these documents. So there's a notice requirement to let people know where to find these things. That notice of intent to use the website must be sent by email to any members consenting to, to receive notice electronically, and by mail to all other members. So notice requirement, hey, this is where we're going to post everything, and you have to show that you sent that out to everybody. All right, we had just a small, that bill, House Bill 59, but it does make some changes to the HOA statute. All right, the last one is House Bill 1503. This relates to Citizens Property Insurance Corporation. There's a lot of changes to it. I'm not going to go through all of those. By no means am I an expert on Citizens. Obviously, we know that generally that is you can go to Citizens potentially if you're having, especially usually it's when you're having issues getting insurance, and you go to Citizens sometimes as a last resort potentially. The change that I wanted to mention, and you can look at the bill to see all the different changes here and some of the reforms that come into play. But really, what happened was there was, if you're in a condo association where at least half of your 50% or more of your units were being rented more than 8 times in a year. So again, a community that has vacation rentals, short-term rentals, and if a bunch of those units were being rented every year, previously that type of condo would be exempt. They're not eligible for windstorm coverage provided by Citizens. They've eliminated that exemption. So the takeaway from this is if you're in a condo or if you manage a condo that has a bunch of rentals, at least a majority of the units that are rented on a vacation rental basis, that now Citizens may be available for the purposes of obtaining windstorm coverage. So that's the big takeaway from that. There's a lot of other substantial, or not substantial, but substantive changes. I just mainly wanted to talk about the eligibility requirements there. All right, so that's what we have for all of the bills. Like I mentioned, those are the ones that passed. We're waiting for the governor to either sign them or to be presented, and then to see if the waiting period goes by. You could see that largely the effective date was July 1st, except for some of them. There might be some, dates on one-off examples like the website requirements, or I just mentioned that October 1st one regarding providing a copy of your rules. But I know, Lee, I saw you come on here that once everything is official, whether maybe you'd be doing another legal update as a refresher that everything passed, or a communication that's provided out for
Sure.
managers, that's when we then can get approval from the division to provide you with continuing education credit. That would probably apply then too for condos. We're waiting for guidance for the board members that have to have legal update credit now. We just can't provide it yet because we have to wait and see if there's anything that gets taken out. So I just appreciate everybody attending though, and all the good questions that we had. But Lee, if anything else that you wanted to say before we signed off, or if any questions came in.
Well, as always, you did an amazing job. It's as you guys can see, there was just a ton of stuff that happened, and Ed told you the results. He didn't tell you all the trauma that went through getting there, especially on the estoppels. I mean, we were till, I don't know, I think midnight on the 7th of March, waiting to see whether or not that bill was gonna
Right.
get cleaned up and we were gonna retain our opportunities to be paid for services that we provide, because it was all going to go away. So yes, we will definitely be sending out the final updates after July 1st. Ed, one question I have for you, and maybe this is up to us internally, but we need to let our board members know that these educational requirements are coming, and they can no longer sign that cute little certificate and go,
Right.
I'm good. CAMs, you need to think about how you're going to do that. You need to make sure you understand the statutes. Obviously, again, it doesn't become effective till July 1st, but it is going to be a different, not only for existing board members, but for people that are going to consider running for the board. They need to know that that's going to be a new requirement
Right.
for them. Yeah. Because that's a
It,
big deal. I mean, there are volunteers already, and now we're gonna tell them they got to go to class, for however many hours. So I want the CAMs to really pay attention. But we had so many attendants. I think at one point we were up to close to 97, and that tells me that this was far-reaching throughout the company. I appreciate all of you. And Ed, as usual, you were a rock star.
oh no, thank you so much. And I think one thing I always like to remind people of is just the power of, and this, Lee, talking with Josh and Mark, like just
Yeah.
the power of homeowners, that if there's something that is really affecting your community, to reach out directly to your legislators, to let them, because they care a lot more what the people voting for them say than, they like the lobbyists, they know that they get paid to do a job though, right? Or, us as, working with community associations and it's part of our
Right.
business, but hearing from constituents, and it's led to legislation that's been passed. And I always give the example of a client in Volusia County that had something passed regarding guardhouse official records. That was because he called Senator Hudson, who then made sure to get it included in one of these bills. and now it's law because of a phone call, right? And not saying that's going to happen every time, but they really like to hear from their constituents. So whether that's you directly contacting or contacting your legal counsel, or Lee, maybe through you all, if there's a method there through Vesta
Yep,
to make sure that it's
sure.
brought up, preparing for it. That's always important, that they like to hear from it from the ground level, what's going on with your communities too.
Well, you guys are the ones that are voting for him, so they
Right?
want you to be happy.
Yeah.
So anyway, Ed, thank you so much. I appreciate you, and to all of you from my Vesta family, thank you all. Your time was appreciated today.
All right. Thanks a lot.